Ladies and gentlemen, good morning and welcome to the latest in Cornerstone Barristers webinar series on legal updates during the COVID-19 lockdown. For those of you who don't know me, my name is Dean Underwood and I am a barrister practicing in housing, local government, public and administrative law at Cornerstone Barristers. And I have a special interest in licensing under the Housing Act 2004. And so this morning, as you no doubt expect, I'm going to be presenting to you a webinar about the recent developments in mandatory, additional and selective licensing under the Housing Act 2004 over the last 12 months. And as you'll have seen from the invitation, this webinar assumes a basic understanding of 2004 Act licensing, and it provides a summary of key developments over the last year, not least recent and significant decisions in the High Court and the Upper Tribunal. It has been an incredibly busy 12-month period, not just in the courts, but also with guidance issued by government. There are numerous developments to consider, and we unfortunately won't have time to consider them all in detail today. I have, however, provided with this presentation a series of PowerPoint slides which are particularly detailed, and you will find in them hyperlinks to the relevant statutory material, to the relevant judgments, and to other material on which you can click to access that material. So please do, either during the presentation or afterwards, click those links and access that material. You will also find on our website some very useful material by the likes of Tara O'Leary, who has written an article on recent developments in 2004 Act licensing. And I'm sure Carolina, who is hosting this webinar today, will send you the link to that shortly. I too have written summaries of recent case law, and those links will also be forwarded to you. Excuse me. We will, during the course of this webinar, be undertaking a poll asking various questions, some of them relevant to designations that are either in place at the moment or expected in due course, and in relation to the types of challenges that you as local housing authorities are facing under the 2004 Act in the tribunals and courts. Please do answer those questions if you're able, and we will try to go through the results of that poll at the end of today's webinar. In addition to that, you will receive a link asking for feedback about today's webinar. Please do fill in the feedback forms. It is vital to our understanding of what you as our clients and potential users of Cornerstone Barristers want from your webinars, and will enable me in particular to formulate and frame webinars in the future. Any queries that you may have about the content of this webinar, please contact me at dnew@cornerstonebarristers.com. Now, without further ado, let me begin the webinar and to that end share with you the PowerPoint presentation that will be available to you at the end of this webinar. And so, as indicated at the start, we're going to be concentrating today on only key developments, and they will be primarily key decisions of the High Court and the Upper Tribunal. I'm going to very briefly cover the guidance that the government has issued recently in the wake of the COVID-19 pandemic, but you again can access that guidance online for further details. The decisions on which I will be focusing are these: Hussain and Waltham Forest London Borough Council concerning spent convictions, Eunice and Waltham Forest London Borough Council concerning the validity of notices of intended penalties under section 249A, Waltham Forest and Marshall and Ustek, which concerns the respect due to local housing authorities' policies and decisions in respect of financial penalties, IR Management Services Limited in Salford, which concerned the strict liability of an offence under section 234, and lastly, the Crown on the application of Mohamed and Waltham Forest, which concerned the strict liability of the offence under section 72 of the Housing Act 2004. Let's begin therefore with the guidance. And so the government has, as I say, in the wake of COVID-19, issued two guidance, one for local housing authorities and another for landlords and tenants of properties in the private rented sector. Now, the latter, as we will see in a moment, is not particularly enlightening, but the former, which relates to local housing authorities, does provide some useful advice and directory guidance about local housing authorities' approach to enforcement during the COVID-19 pandemic. As you will see from the slide, this is non-statutory guidance on enforcing standards in the PRS during the COVID-19 outbreak. And as a result, it is not guidance to which the local housing authority is required to have regard under statute. It is, as you will appreciate, nonetheless, a relevant consideration, and local authorities should therefore take it into account when making decisions over the course of the next weeks and months. In a nutshell, that guidance recommends that local housing authorities take a pragmatic and realistic approach to enforcement during this difficult period, and that it only undertakes such enforcement action as it considers necessary during that time. And so it recognises and understands that local housing authorities and indeed landlords will still have obligations, statutory and otherwise, during the pandemic period. But as you'll see from halfway down the slide, it recommends that a pragmatic approach to enforcement, which ensures that tenants are kept safe and landlords supported, basing all decisions that local authorities now take on a careful risk assessment. Importantly, and local housing authority officers and solicitors should take note, it recommends that LHAs update their policies, enforcement policies and otherwise, for example, about when and how officers undertake inspections, and indeed how they will respond if, for example, they are unable to gain access to a property, whether because the occupants of that property are self-isolating because of COVID-19 or otherwise. And so some possible responses it suggests maybe deprioritizing lower risk hazards and, for example, using video link assessments to assess the existence of potential hazards in an HMO. As indicated before, and you'll see from the bottom of the slide, local housing authorities should only take the enforcement action that they determine is necessary, and in fact should consider suspending all non-urgent proactive work where there is not a duty to carry this out, and instead prioritizing reactive work. Now, what does that mean? Well, many local housing authorities will, during the course of a designation, undertake certain proactive enforcement days, inspecting numerous properties on one day to check for compliance both with license conditions and to assess whether there are any hazards under Part 1 of the 2004 Act. That work, the government recommends, should perhaps be put on hold, and instead local housing authorities should react to complaints that are made about specific properties and deal with them accordingly. Now, in respect of licensing in particular, it recommends certain steps by local housing authorities, and you'll see them itemised there in 4 bullet points, including contacting landlords who are waiting for licenses to be determined to explain that in light of, for example, furloughed staff, there may be delays in processing licence applications. Those applications, nonetheless, still have to be processed. It indicates too that local housing authorities should prioritise high-risk licensable properties if that is necessary to protect the vulnerable tenants and target imminent risks to health. And that goes back to the last slide in which it was recommended that in fact local authorities undertake reactive work as opposed to proactive work. Local housing authorities should continue as usual for non-mandatory licensing schemes already in place. But again, as with all enforcement, the government recommends take a pragmatic and common sense approach to enforcement. And where local housing authorities are in the process of introducing non-mandatory licensing schemes, it does suggest that it consider pausing those schemes at an appropriate point in line with the advice on proactive and reactive work. And that is an approach that some local authorities across the country have adopted and others have chosen not to. We'll come back to that perhaps in response to some of the questions that have been asked ahead of today's webinar. We'll leave the guidance for local housing authorities there and turn very briefly to guidance that has been issued by the government for landlords and tenants. And as I said before, this is not particularly enlightening. It does in fact deal with a whole range of issues, including, for example, the recovery of rent arrears, dealing with disrepair issues, court proceedings, and for today's purposes, licensing. And in that regard, it answers some frequently asked questions, including whether, for example, in light of the COVID-19 pandemic, landlords can remove occupants of HMOs and other houses. And the answer to that is nobody can be removed from their home because of this virus. And indeed indicates that landlords are not obliged to provide alternative accommodation for tenants if others in the property contract the virus. They should follow the usual government guidance about self-isolating and social distancing. As I say, not particularly enlightening, and much more assistance, I suspect, will be taken from the guidance issued to local housing authorities. Now, given that we are pressed for time, I'm going to leave the guidance there and turn instead to other key and recent developments in 2004 Act licensing, and in particular, decisions made in respect of licensing rather than procedure under the 2004 Act. The first of those decisions, if we skip through these slides, is the case of Hussain and Waltham Forest London Borough Council. Now, Hussain and Waltham Forest London Borough Council was a case that was run in the upper tribunal by James Finlay, QC of Cornerstone, and Ricardo Calzavaro. And it concerned a case in which Waltham Forest had refused and revoked numerous licenses under parts 2 and 3 of the 2004 Act by reference to and relying on conduct which had amounted to offences of which Hussain and indeed her husband had been convicted under section 238 of the Housing Act 2004, providing false or misleading information, and the Forgery and Counterfeiting Act 1981. And Hussain had appealed to the first tier tribunal and applied to strike out all references to that conduct on which the local housing authority had relied. And they did so on the premise that the convictions had become spent after a period of 1 year under section 4 of the Rehabilitation of Offenders Act, and that Waltham Forest should not therefore have had regard to them. Now, section 4 of the 74 Act, which, as I say, you will find if you right-click on the link provided, is a rather complex provision, but which in essence provides a series of, as I say, complex protections for those who have been convicted of an offence, but due to the passage of time, are considered as a matter of law to have been rehabilitated. And so, for example, the period of time after which somebody who has been convicted of a licensing offence which is punishable by way of a fine only is 12 months. And after that period of time, certain protections apply, including a prohibition on, for example, any reference to the fact that that person has been convicted or sentenced for that offence. Because of its importance, this application was transferred to the upper tribunal. And in due course, the upper tribunal, in a rather lengthy and, if I may respectfully say so, erudite judgment, dismissed that application. It all turned on the proper construction of section 4 of the 1974 Act. That, the tribunal held, enabled the first tier tribunal to receive and take account of evidence and indeed submissions dealing with relevant conduct of a rehabilitated person, excuse me. And that conduct included conduct which had been treated as an offence in criminal law, which had nonetheless resulted in a now spent conviction. So while in fact, ordinarily, the first tier tribunal would not be able to refer to the spent conviction or indeed the sentence that the person had received, it was perfectly legitimate for the first tier tribunal and the tribunal held Waltham Forest to have regard to the underlying conduct. And that rather makes sense. It would be rather absurd, for example, if the local housing authority could have regard to serious and potentially criminal conduct, which for various reasons had not resulted in a charge or conviction, but could not refer to that same conduct, even though that person had duly been convicted. The upper tribunal also held that because upon a proper construction of section 4, the local housing authority was a judicial authority, then it could require and seek evidence about spent convictions if it found that justice could not otherwise be done in the decisions that it was taking. Similarly, it held, because the first tier tribunal is a judicial authority, it too could, in principle, emit evidence about spent convictions if the local housing authority could discharge the burden of proving, very much like when it considered the issue itself, that justice could not otherwise be done unless the spent conviction and/or sentence was referred to. As I say, a complex and very erudite judgment, which really is worth the read, but in a nutshell, that is it. Even if a person has been convicted and that conviction has become spent, local housing authorities are entitled to have regard to the underlying conduct when they consider issues concerning, for example, the fitness to hold a licence and whether in fact a licence already in existence should be revoked. The next case that we will look at is in fact the case of Waltham Forest and Eunice, which for some reason doesn't appear to be available on legal research databases or indeed on Bailey. It is a case run to the upper tribunal by my cornerstone colleague, Ashley Underwood QC. No known relation, I hasten to add, although rumour has it that Ranjit Bose is still trying to obtain the DNA samples. This case concerned the adequacy of reasons given in a notice of intended financial penalty. As you may or may not know, notices of intent to impose a penalty must comply with certain formality requirements. And so under paragraph 3, schedule 13A to the 2004 Act, it must set out the amount of the penalty, the reasons for imposing the penalty, and information about the right to make representations to the local housing authority. Now, in this case, Waltham Forest had served a notice on Mr. Eunice for breaching a condition of his Part 3 licence, condition 20, which was contrary to section 95(2) of the 2004 Act. And in this particular case, allegations included the use of the Part 3 house as a gambling establishment and environmental nuisance and annoyance that had been caused by providing food at the premises, including drying fish and hanging them outside, which one might readily understand was capable of causing a nuisance and annoyance to neighbours. Now, in the notice and the covering letter, Waltham Forest didn't elucidate the details of that offence, but exhibited statements to the covering letter and the notice which explained them and set out the premise of the offence being committed. And in the course of that letter, it also referred Mr. Eunice to its enforcement policy by which, and according to which, it had calculated the amount of the penalty. Now, Mr. Eunice later appealed against Waltham Forest's final penalty notice, and he argued before the first tier tribunal that the reasons given by Waltham Forest and the notice itself from a formality perspective was invalid, and the reasons insufficient. And the first tier tribunal found for him. It found that in the covering letter and the notice itself, the reasons given by Waltham Forest were not sufficient, and that the notice was therefore invalid, and Mr. Eunice's appeal was allowed. As I say, Waltham Forest took that case to the upper tribunal, and the upper tribunal found that, in fact, the notice was valid. So a notice of intention to impose a penalty must provide a sufficient amount account of a local housing authority's reasons for imposing the penalty to enable the recipient to understand what conduct or omission amounts to the offence. In this case, it held Waltham Forest had done so, even though it had not set out the details in either the covering letter or, more importantly, the notice itself. There was no reason, the tribunal held, why local housing authority reasons could not be set out in more than one document, as in fact they had here by the exhibiting of numerous statements. Nonetheless, the tribunal held that was not really a recommendable approach, and rather a concise statement of facts of the offence would have been preferable in the notice itself. Further and importantly, the upper tribunal held that a mere link to an online policy would not be enough to explain the amount of the penalty, and further detail would be required. But here, ultimately, Waltham Forest had provided enough information with its notice of intended penalty. Importantly, as well, as an addendum to the judgment, the upper tribunal considered whether, if there were an insufficiency of reasons, whether that would invalidate the notice. And the answer to that question was not invariably. So insufficiency of reasons will not invariably invalidate a notice of intended penalty, even if Waltham Forest reasons had been defective. In this case, Mr. Eunice had not been prejudiced. He had had the benefit of legal representation. He had responded in detail to the notice of intended penalty, and in fact, in those representations, had made no complaint about the inadequacy of reasons or his inability to deal with the case against him. And so, because there was no prejudice caused to him, the notice was sufficient to do its job, and the upper tribunal so held. We leave Eunice there, and we proceed to the next of our 5 cases. The case of Waltham Forest, London Borough Council, and Marshall and Ustek, in which I had the privilege of leading 2 of our impressive juniors in chambers, Ricardo Calzavara and Tara O'Leary, in the upper tribunal. You'll notice a common theme here. Again, this is a Waltham Forest case, and Waltham Forest is particularly proactive and proudly so of its enforcement record and policies. This case concerned one such policy in respect of financial penalties. Waltham Forest had imposed financial penalties on Mr. Marshall and Mr. Ustek under Section 249A of the 2004 Act for failing to license flats under their control under Part 3, contrary to Section 95(1). It had calculated those penalties according to its licensing enforcement policy, and principally according to the seriousness of the offence. Now, that policy categorised offences and the penalties which applied accordingly by reference to a civil penalties matrix, and in particular 6 bands, 1 to 6, which, as you go through the bands, increased the level of the penalty. Mr. Marshall's offence, as it happened, fell within band 2, and Mr. Ustek's within band 4, and they were penalised accordingly at the very bottom of those respective bands. £5,000, Mr. Marshall's case, £12,000, Mr. Ustek. On appeal, the first tier tribunal had, rather surprisingly, and to Waltham Forest's alarm, reduced Mr. Marshall's penalty to £1,000, which was the equivalent of a low penalty for a band 1 offence, reserved for the most minor offences under the licensing provisions, and Mr. Ustek's to £4,000, a reduction of £8,000, which was equivalent to a high penalty under band 1. Unsurprisingly, perhaps, Waltham Forest appeals. This was the first case to consider in this context the deference and the respect that should be given to local housing authorities' policies and decisions when making financial penalties under Section 249A. And so the key provisions, key findings are these. The first tier tribunal may not entertain challenges before it to the local housing authority's policy. Only the administrative court presently may do so. And so as a result of that, if an appellant wishes to challenge the lawfulness of that policy, for example, because it is alleged to discriminate unlawfully against him or her, they would have to stay the proceedings and proceed with a judicial review before the admin court. As far as applying that policy goes and the respect due to it, the first tier tribunal, the upper tribunal held, must start from the local housing authority's policy. It must consider any arguments that it should depart from it, but should depart from it only in certain and very limited circumstances. And it is the appellant who bears the burden of persuading the first tier tribunal to do so. When considering whether to depart from the policy, importantly, the first tier tribunal must look at the policy's objectives, and it must ask whether they can still be met if it departs from the policy. And then perhaps just as importantly, if not more importantly, it must consider the need for consistency between offenders. That is ultimately the reason why policies are adopted. They frame and they structure the exercise of a discretion in order to provide consistency and transparency to those to whom it applies. And that is a key consideration when a first tier tribunal considers whether, notwithstanding the policy, it should make a different decision. That dealt with the policy under consideration. In respect of the decision itself taken by the local authority, it was also recognised that the first-tier tribunal must afford considerable weight, and indeed special weight, to the local housing authority's decision, following a long line of authority. That was understandable, I think, in my view, given that the 2004 Act, throughout, certainly its licensing provisions, is framed in terms of the local authority having to make decisions, the local authority considering, or the local authority being satisfied. It is on the local housing authority that Parliament has chosen to confer the primary decision-making function, hence the respect that was due to Waltham Forest decisions, and indeed those of any other local housing authority. On the facts of this case, the first-tier tribunal had, at the upper tribunal held, paid only lip service to Waltham Forest's policy and indeed its decisions. It described the penalties imposed in this case, which you'll recall were at the very bottom of bands 2 and 4 respectively, as particularly generous. There were aggravating features of the case which might have taken those penalties further up the scale of those particular bands. Having given that guidance in respect of policy and decisions, the upper tribunal reinstated both penalties. Now, that is perhaps a useful yardstick for local housing authorities when it takes, or rather responds to, appeals before the first-tier tribunal. The extent to which the amounts of penalties imposed in certain cases is relevant to the penalties proposed and imposed in others is limited, but nonetheless, the fact that this was described, or these were described as generous policies, may provide a frame of reference and a yardstick for local housing authorities in the future. Time being against us, we move on from Marshall and Mistec to another important decision. And that is the case of IR Management Services and Salford City Council. Now, IR Management Services concerned the inspection of a house in multiple occupation, which was managed by IR Management, and Salford City Council had identified breaches of Regulation 4 of the Management of Houses in Multiple Occupation Regulations 2006, as a result of which, as it was entitled to do under Section 249A of the 2004 Act, it had penalised IR Management Services £25,000 for the related offence under Section 2343 of the Housing Act 2004. In short, a breach of regulations made under Section 2343 amounts to an offence subject to a defence of reasonable excuse. On appeal against that penalty, the director of IR Management Services maintained that he did not know the house was an HMO, and therefore it was contended had a reasonable excuse for the offence under Section 2344. The first-tier tribunal directing itself about that statutory defence indicated that it was for the director of the company to prove that it had a reasonable excuse on the balance of probabilities, and that it had not done so, it had not discharged that burden, and in fact it increased the penalty as it is entitled to under Section 13A of the 2004 Act from £25,000 up to £27,500. IR appealed against that decision on two grounds. One of them is immaterial for today's purposes, but one was that the first-tier tribunal had applied the wrong burden and standard of proof when considering the statutory defence under Section 2344. It was argued on IR's behalf that it had only an evidential burden. In other words, once it had produced sufficient evidence to support the possibility of a defence of reasonable excuse, the burden shifted to Salford City Council, it was said. And it had to then prove to the criminal standard that IR had no such excuse. In other words, ultimately, the effect of this argument was that the absence of a reasonable excuse would become an element of the statutory offence itself. That argument, as you will see, was rejected by the upper tribunal. A failure to comply with the 2006 regulations under Section 2343 is a strict liability offence, and the elements of that offence do not include the absence of a reasonable excuse. And so it was not for Salford City Council in this case, and will not be for any other prosecutor under section 234, to prove the absence of such an excuse. The burden of raising that excuse and proving it to the civil standard of proof, i.e. the balance of probabilities, rests with the defendant, or as the case may be, in the case of a financial penalty, the appellant. I've taken you to that decision because it becomes relevant to our next decision under consideration, which is the case of Crown on the application of Mohamed and Waltham Forest London Borough Council. This was a case in which I have acted since 2017, and in which I had, again, the privilege to be led by Ashley Underwood QC, instructed by Simon Keeley at Sharp Pritchard. As for the facts of the case, in 2017, in January, Waltham Forest had prosecuted Mr. Mohamed and his wife for failing to license houses in multiple occupation, contrary to section 72(1) of the Housing Act 2004, under Part 2. Later, in about August that year, it had invited Mr. Mohamed alone to an interview under caution on suspicion that he'd committed a further such offence. In fact, it was suspected that he was reletting or continuing to let one of the houses which was subject to the January prosecution as an HMO. In response to that invitation, Mr. Mohamed and his wife sought a judicial review of Waltham Forest's decision to interview him. And he alleged that Waltham Forest's approach to that decision had been entirely wrong because it had treated section 72(1) as a strict liability offence. Mr. Mohamed later also sought a judicial review of the Magistrates' Court decision in the prosecution, which refused to treat the summonses that it had issued against him and his wife as a nullity, on the premise that, firstly, Waltham Forest had not provided the court with, and it was said the court did not have, enough information about the offences to issue summonses lawfully, relying on the authority of Klan, K-L-A-H-N. And secondly, that Waltham Forest had not laid informations in time, as section 72(1), it was said, did not create a continuing offence. And secondly, Waltham Forest had known about the offences in 2015-16. So time, it was said, for the purposes of bringing a prosecution under section 127 of the Magistrates' Court Act 1980 had begun to run long before January 2017 when the informations were laid. Those two claims for a judicial review were joined for hearing before the Divisional Court. And it was held by the Divisional Court, you will find the link to the decision here, very recently, that section 72(1), like the offence under section 234, created an offence of strict liability. It was not one of the elements of the offence that Mr. Mohamed or his wife knew that the property of which they had control or were managing was a house in multiple occupation, and Waltham Forest did not have to prove that as an element of the offence in order to establish that offence. So a lack of knowledge that a house was occupied as an HMO was not relevant to the establishment of the offence per se, but it was held might be relevant to whether the defendant, or in the case of a financial penalty, an appellant, had a reasonable excuse for the section 72 offence under section 72(5). That decision was one which reflected indications that were given in a case called Thanet and Grant. I believe one of our participants today was involved in that case, and indeed was also referred to in the case of Sutton and Norwich, which you'll find on the preceding slide. Now, at the hearing, it was conceded on Mr. Mohamed's part and his wife's part that section 72 created a continuing offence. It had not been conceded to that point and had been fully argued. But in light of the decision in Luton Borough Council and Althaven Luton Limited, which you'll also find summarised on a preceding slide, Mr. Mohamed conceded that that position could no longer be sustained. He did, however, maintain that for the purposes of the limitation period for commencing a prosecution under section 127 of the Magistrates Court Act 1980, in other words, 6 months from the date on which the offence was committed or the matter of complaint arose, that time began to run either when the offence was committed and the elements of the offence were made out, or at the very latest when the local authority knew that an offence had been committed. And for that reason, he said that the information laid was still out of time. The court rejected that argument. Not only had it been addressed in Oldhaven and Luton, which again you'll find on the preceding slides, but it simply did not withstand scrutiny or accord with the proper construction of section 127. There was a further point, which I referred to previously, that it was alleged that the information given by Waltham Forest in this case, which had set out a very brief description of the offence, setting out the elements of the offence, their bare ingredients, and relevant details about the date and the name of the defendant and the address to which it applied, that they provided insufficient information for the court to be able to lawfully issue summonses. And it was suggested that either Waltham Forest should have provided more, or the court should have made inquiries to obtain more. The court rejected that argument. The informations in this case were sufficient to serve their purpose. The court had sufficient information with which to issue summonses, and the informations importantly complied with criminal procedure rules relating to the form and substance of informations under Rule 7. And so perhaps somewhat of a relief to local housing authorities, many of whom I've no doubt issue summonses, informations rather, in this form, that was found to be adequate. Further and importantly, a point which is not included on this slide, applying the case of Nash and Birmingham Crown Court, the Divisional Court held that even if there had been an insufficiency of information in the information themselves, or the summonses had otherwise been irregular, provided the defendants were given sufficient information to fairly meet the case against them before trial, then the summonses would not be invalidated. That, as you'll appreciate, is a very important decision. An appeal from this decision goes straight to the Supreme Court. We don't know yet whether that opportunity will be taken. We will know in due course. I should add, actually, on the substance or on the point of appeals, that the case of Hussain and Waltham Forest London Borough Council, to which I referred previously, is currently being appealed to the Court of Appeal. Ashley Underwood QC and Ricardo Calzvara are dealing with that before the Court of Appeal, and I believe it is listed, floating at the moment, from the 11th to the 12th of November 2020, later this year. I have included in this presentation a series of further slides which deal with procedural developments. You'll find, for example, references to guidance that has been issued in respect of listing before the first tier tribunal, the upper tribunal and magistrates courts, and two important decisions about the discretion of the first tier tribunal to extend time for appeals before it and the principles on which that discretion should be exercised. I don't have time to go through them today, unfortunately, but I'm sure you'll find them relevant and of interest, and you are, of course, at liberty to go through those slides and the links which are contained in them at your leisure. Given that we have almost exceeded our time already, I'm going to end this part of the presentation here. I'm going to stop sharing my slides with you, and we are going to undertake a very short question and answer session, most of which will focus on questions submitted by you, the participants, before this webinar. And to that end, let me, in fact, I said I was going to stop sharing my screen. I'm going to share with you those questions so that you can see the queries to which I'm responding. And I appreciate that many of you have sent in questions, and my sincere apologies for not being able to deal with them all today. Nonetheless, I'm going to deal with those which perhaps are most topical and raise current issues. So the first of those, raised by Luton Borough Council, is, are local authorities delaying the implementation of additional and selective licensing schemes, and if so, for how long? It may be that I'm not best placed to answer that, but from my experience, and as you'll see from the very helpful article that Tara O'Leary wrote, experience varies across the country. So Waltham Forest have recently proceeded to bring their recent selective licensing designation into force on the 6th of April, and will be enforcing that designation in due course, of course, by reference, I understand, to the current guidance. By contrast, Newcastle City Council has, although it has brought its designation into force, has indicated that the period for compliance with it will be extended until July 2020 in light of the current pandemic. And for example, Coventry City Council has indicated that in respect of its designation, it would not expect and will be more lenient in respect of certificates relating to property conditions to be provided if, for example, that is impossible because of the pandemic. So the short answer is experience varies from borough to borough, from county to county. Local authorities should take into consideration the government guidance and make their decisions accordingly. Second question, are COVID-19 restrictions potentially a reasonable excuse for property owners and managers who fail to license or fail to comply with management regulations and license conditions? The answer to that is potentially yes. Whether on the facts of any individual case it is sufficient to amount to a reasonable excuse will depend, of course, on those facts. And so, for example, one can well conceive of circumstances in which, in order to let a property as a house in multiple occupation, certain work was required in order to comply with room size standards, but can't be undertaken because of the COVID-19 pandemic. Well, without more, one can see that that would readily amount to a reasonable excuse. By contrast, if non-compliance comprises the failure to provide the occupants of an HMO with the license holder's name, address, and contact details, well, one could expect that there may be ways of dealing with that, short of actually visiting the premises itself. It might be possible, for example, to post a copy of that notice through the door and invite the tenants, the occupants, to post it up, of course, following COVID-19 guidance, making sure to clean their hands, etc. afterwards. So the short answer is, in principle, yes, it can, but whether it does will depend on the facts. Another question from BCP Council. Due to COVID-19, we're considering issuing licenses without carrying out the inspection first and delaying it until the situation improves. The licenses will be issued with our standard conditions, amenity standards, and fire precaution standards, which will be checked on what would normally be the revisit. Is there any concern with taking this approach? That's probably a question that requires more detailed consideration than we have time for, but there is some concern because, of course, the local authority must be satisfied that the HMO is suitable for occupation by the number of persons that it perceives to be the maximum suitable or appropriate in its license. And it may be difficult to reach that conclusion without actually seeing the property itself. Now, it may be that there are ways around that. It may be, for example, that a virtual inspection can take place. But again, a decision in each case will have to be taken on its facts. In an appeal before the first tier tribunal against a financial penalty, do the rules of evidence applicable to criminal proceedings apply, or those relating to civil proceedings? That is a very good question raised by one of our housing consultant participants today. And you will find the answer to that, rather regrettably, in the case of Waltham Forest and Eunice. Now, I can provide you with a copy of that decision if you email me or our marketing team, but I believe at paragraph 48, it is said by Martin Roger QC, Deputy President of the Tribunal, that these are civil proceedings, and that although some of them concern the commission of criminal offences, which must be proved to the criminal standard of proof, nonetheless, it is not the criminal procedural and evidential rules that apply, it is the rules that apply before the tribunal, as set down in statutory tribunal rules. So as I say, have a look at the decision in Eunice, and you will, I think, find the answer you seek. Lastly, for today's purposes, following the Secretary of State's recent rejection of a citywide selective licensing scheme, do you foresee any similar problems for other authorities who may be renewing their schemes in the near future? The question posed by Newham. That is perhaps a difficult question to answer. I think the question probably refers to Liverpool's experience. a particularly difficult one, is that the government, in accordance with recent guidance, is taking the proposed designation of large geographical or citywide designations very seriously, and really requires very robust evidence to justify such a widespread designation. The key in all these cases, if you're acting for or employed by local housing authorities, is to ensure that you have your evidence before you make a submission to the Secretary of State, and evidence that backs up each of the conditions on which you propose to designate. That can be obtained from a variety of sources. We don't have enough time to go into them today, but it's a question of really setting that out in sufficient detail and answering all of the Secretary of State's questions in sufficient detail to be able to satisfy them that confirmation is justified. Now, during the course of today's webinar, you will have received a poll, and that poll asked a series of questions to which we now, as you, I think, can see, have the answers. The first of those questions, to deal with them very briefly, was, does your local authority currently have an additional licensing designation, selective licensing designation, neither, or both? And it would appear that of those who are participating today and from a local authority background, 48% of local housing authorities participating today do not have either such designation, only the mandatory licensing scheme for which Part 2 provides in respect of HMOs. Is your local authority considering, or in the process of considering, consulting about either an additional licensing designation, a selective licensing designation, or neither? And again, the majority seems to be that neither. There is 36% response to the question in respect of selective licensing, less so in respect of additional licensing. And a very small proportion, as you will see, are considering both. As far as question 3 is concerned, what percentage of cases before the first tier tribunal proceed to the upper tribunal? And the vast majority of those responses suggest that most are dealt with and disposed of finally at first tier tribunal level. 63% of you responded that that was the case. Of those that responded otherwise, 25% indicated that the percentage of cases proceeding from FTT to upper tribunal was between 1 and 10%, so a small minority of such cases. An interesting statistic. Has your local housing authority ever been party to a claim for judicial review because of issues arising from additional or selective licensing? 18% say yes, 83% no, suggesting that those challenges are few and far between. And is your local authority currently threatened with judicial review proceedings because of issues arising from 2004 Act licensing? Again, a very small proportion, 6% say yes, and a much larger proportion, the vast majority, 94%, say no. So it would appear from that poll that the vast majority of challenges that are brought to licensing decisions are taken in response to individual decisions before, for example, the first tier tribunal, less so before the upper tribunal, and that relatively few proceed to a judicial review on administrative law grounds. Well, that deals very briefly, I appreciate, with the poll. It also brings to an end this webinar on mandatory, additional and selective licensing. It has been, I appreciate, a whirlwind tour of recent developments, and of course not all of them have been covered. You will have, in due course, nonetheless, a copy of my slides in which, as I say, there are links. Before I close today, I should say that this is a specialist area of practice for me, and I am indeed writing a book on the subject, which is due out later this year. But it would be remiss of me not to mention the other members, good friends and colleagues in Chambers, who have an expertise in this area of law. We are blessed at Cornerstone with, if you like, an embarrassment of experience and intellect, both at junior and senior level. We have, for example, Ricardo Calzavara, Tara O'Leary, Rowan Clapp, Alex Williams, all excellent, impressive juniors. And I apologize to those who, for reasons of time, I have not mentioned. When it comes to the senior end, we are again embarrassed by a wealth of experience and intellect at silk level. Ashley Underwood QC, Ranjit Bose QC, Kelvin Rutledge QC, Matt Hutchins QC, James Findlay, all with experience of selective and additional and mandatory licensing under the 2004 Act. And so the short message is this: if you have an issue under the licensing provisions of the 2004 Act, Cornerstone Barristers really is in the best position to be able to assist you with that. So please, if you have an issue, contact me, or please contact the clerks, get in touch, and we would be delighted to help you. That brings to an end today's webinar. I hope that you've enjoyed it. There will no doubt be more webinars coming up from Cornerstone Barristers. Please stay in touch, please get in contact, and most importantly, at this difficult time, please stay well. I look forward to catching up with some of you very soon. Thank you very much.